Hello, Tariq Samar, Tariq Ade here.
Already Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
It's going to be a Bellinger thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here, so I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're gonna do. Then I'm gonna say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're gonna represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay, and at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line. Why don't we do this? Give me about 3 minutes. I'm going to take a recess, then I'm going to come back because everything's going downhill, and it's those two guys' fault. What's your name?
Tariq Samar, Tariq Ade, the executive of the Tariq Samar, Tariq Ade Living Trust. Last owner, Tariq Ade, Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right. You understand at your arraignment you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding, 3rd degree.
3rd degree, correct. And if anything else was tallied onto that, then I was not told.
I have 1 charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
As soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct, I comprehend.
All right. You also So I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest, cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Done. Finished?
Oh no, actually, I was also moving to place you and the clerk as fiduciaries over the trust, and I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits.
To whom?
To the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demurred. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demure and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not.
No need to.
They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my
Do
motion,
you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs
You
to.
don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing with
Mr. Allen,
discovery.
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Do we have copies of discovery available that can be provided to this defendant?
No, Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. Sir, are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All right.
Documents.
All right. Those need to be gotten to the defendant.
Yes, sir.
How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him?
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it Sheriff?
I do, Your Honor.
Okay.
Or,
Okay, gotcha. All right, you'll make sure that that is sent to him.
I will.
You also have an email address so that all things can be emailed to him also?
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it, because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, and Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that,
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing, because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you, and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So, dude, that would be the next step. Then I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case, April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date
So,
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
just for the record, I put it on the record that I object, but under threat, duress, or coercion, again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here.
Well, it does call the case, People versus Tariq Day.
Senior Assistant Prosecutor for New Jersey.
I am Tariq Samar Tariq Day, the executor of the Tariq Samar Tariq Day Living Trust, and the registered owner of the Tariq Samar Tariq Day Ex Relatione Kingdom Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and/or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court will ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant, stating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. How religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the government should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No.
So I do have.
Sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there a
You are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution, as well as the court and the officers, agree to take a
That's
competency.
not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this
Yes, sir.
because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. Not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes. I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
Would the court ask the people to prepare the order for the competency?
Yes, please prepare the order for the competency, if you would, sir.
And the address for,
The defendant,
I see on the complaint is 1410 Share Avenue, apartment 1-3.
is that your address, sir?
Excuse me. That is correct.
All right. All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. And man, you're gonna figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
The situation reached a critical moment when the court ordered a competency review. This step often marks a pause in the proceedings, but it is important to understand what it truly represents. It is not a penalty, and it is not meant to single anyone out. Instead, it functions as a legal protection built into the justice system to preserve fairness. When a defendant appears uncertain about the process or misunderstands the consequences of their actions, the law requires the court to step in. Judges are obligated to confirm that the person standing trial fully understands what is happening. This is not a judgment of character or mental health. It is a practical question of understanding. Can the individual grasp the charges? Can they participate meaningfully in their own defense? That is why Judge Simpson's decision to send Tarek for forensic evaluation followed standard legal practice. It was not influenced by personal views or assumptions. It was a necessary step to ensure that any future hearing is conducted properly and that the defendant is fully aware of what is at stake. Without this safeguard, the integrity of the trial itself could be questioned later. This moment raises an important discussion. Should the court have continued allowing more argument, or was it appropriate to set a boundary once it became clear that the claims did not align with established law? This case invites viewers to reflect and share their perspective because the issue extends far beyond one courtroom. At the heart of this matter is a larger question about where personal belief meets legal responsibility. Individual freedom is a core value, and personal autonomy matters deeply. However, when personal ideology enters a legal setting, it must operate within structured rules. The courtroom is not a space for personal interpretation to override legal standards. In this case, that delicate balance was clearly visible. Tarek remained calm and confident, firmly believing in his position. His composure never wavered. Yet, despite that confidence, the legal facts did not change. The court retained authority, the charges remained in place, and the judicial process continued forward as required by law. What stands out most in this exchange is a reminder of how the justice system functions at its core. While it is not perfect, it is designed to follow procedure rather than emotion. Decisions are guided by rules, not reactions, and by consistency rather than personal feelings. Judge Simpson's conduct reflected that principle. There was no hostility, no ridicule, and no loss of control. Instead, the judge maintained professionalism, applied the law carefully, and demonstrated patience throughout the exchange. That kind of restraint often goes unnoticed, yet it plays a critical role in maintaining trust in the system. So the question remains open for discussion. Who handled this situation correctly? Was the judge overly firm, or was he simply carrying out his duty as required by law? This case encourages deeper thought about fairness, responsibility, and the boundaries that keep the legal system functioning for everyone.